Court does call the case. People, State of Michigan versus Justine Cheatham.
Good morning, Your Honor. Marie Campbell, Assistant Attorney on behalf of the people.
Good morning, Rep. Jacob on behalf of Destiny Cheatham, who's on Zoom, and we do appreciate you allowing her to be on Zoom. Destiny, would you state your name for the record, please?
Destiny Cheatham.
Do you have a camera, Destiny?
No, I don't. My screen is shattered.
Okay, I know her voice, Judge. That's her. What we'd like to do
Or
today.
either you're going to waive.
Yes, Judge.
Does either party have an objection to her not having a camera?
No.
I'm
Do
sorry.
you object to her not having a camera?
No, you're.
All right, very good. All right. It's going to be a waiver.
Yes.
Ms. Cheatham,
Yes.
you understand that you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing today and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Judge, we acknowledge the information, waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty. The pretrial will be set for July 8, 2025, 1:30, Judge Conkey.
Thanks, Judge. Judge, we do appreciate allowing my client to appear by Zoom. Thank you.
No problem. Yes, just one moment. Bond will continue in this matter.
Thank you, Your Honor.
Court does call the case, People versus Sean Odom.
And on behalf of the people, Your Honor.
Good morning, Your Honor. Good morning to your honorable staff. If you please, this court, Brandon Bird, PA 3734, on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You welcome.
All right.
Preliminary examination. At this time, people are unable to proceed as to count one, whereas the count two and the added count three on the amended complaint be remanded to district court.
All right. As to the amended count three, the domestic violence second offense, you waive formal reading of that charge, counsel, and your client pleads not guilty.
Yes, Your Honor.
All right.
Respectfully.
You need a copy of it?
Right, I never seen the amended complaint, Your Honor.
Did you want me to pass it so you can go over that with your client?
Yeah, let me please.
Okay.
Your Honor.
So I'll pass the matter. We'll take him back, then you can go around and talk to your client. Call it back up. Court does recall the case. People versus Sean Odom.
Alexander on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you state your name for the record again?
Sean Martell Odom.
Thank you.
You welcome.
All right.
Yes, Your Honor. We did get a chance to discuss this with my client. Understandable. We're gonna wait a formal reading, stand mute.
All right. Court will enter not guilty plea as to that count three. Maintain his plea of not guilty as to count two. Count one will be dismissed. I'll set a pretrial on counts 2 and 3 for May 28, 2025, 9 a.m. That is before Judge Perry at the 15th District Court on the misdemeanor charges. All right.
Permission to address bond, Your Honor.
Figured you would. Go ahead.
Respectfully, we got the misdemeanor that was dropped today. It's the same complaining witness that's on this case. That's just been dropped to the domestic violence second. So I'm not sure really how far this case is gonna go, but that's something we'll see in district court. Essentially, my client has been in jail for since March.
Yeah, about a month.
About a month. Roughly about a month now. Now it's pushed back almost 2 weeks, Your Honor, for 2 misdemeanors, which essentially could potentially be probationable, or
You got
it's almost like he'd be serving a sentence if he stays in jail too much longer. One of these is a 93-day misdemeanor. I understand the other one's up to a year. But respectfully, we're gonna ask for a personal bond in this matter. He understands no contact with the complaining witness. He doesn't want any contact with the complaining witness. My client doesn't want to be sitting in the jail cell like
he had a personal and then messed that up.
Understandable, Your Honor, but now we're dealing with a whole new set of situations in which my client's been sitting in jail for a month now, almost a month. And I'm pretty sure a month in jail gives you a lot of time to think about where you want to be and where you don't want to be, and how you operate.
Go back to work.
Severe concerns that he could file court orders. He did pick up that bond violation where he was in contact with the victim while out on bond and had another assaultive incident with her. And in this case, he had an assaultive incident with her and her child, giving the child a black eye. I also think that because he's currently on probation in 15 for living with this same victim. So I don't believe he can keep himself from being in contact with her. And I have great concerns for her safety and her child's, given the facts of this case and his previous history with numerous dismissed DVs and convictions on DV.
Anything else, Council?
Respectfully, Your Honor, my client went to, he went to the police station. He went to the police station and made a police report in Ann Arbor, in Ann Arbor. That's one of the reasons for the contact.
So just, right, but here's what ended up happening. He had a personal bond. He didn't follow the conditions. He then came into custody, was arraigned, and the bond was set at where it is now. As a result of his failure to follow the conditions. And then that is even really outside of the other stuff that the prosecutors indicated regarding the other contacts and other complaints that he has with the victim in the case. What I'm going to do is I'm going to deny your request to reduce his bond. You can take it up with Judge Perry, but at this point, I'll do it that way.
Thank you.